Hi, very good morning, and welcome back to the third learning outcome for the unit that we've been covering this week, which is business law. I would like to do a quick recap in terms of what we've covered so far in this particular unit, and would be happy to take any questions or if you have any queries by email or through the chat route. Now, so far in this particular unit, what we've done is we've looked at the basic background in terms of why we want to study business law in management. Because most businesses, organizations are governed by some sort of law and legislation, and individuals which work within different functions need to be able to understand, how this law and legislation can be applied in given business situations. Now, in the first learning outcome, we basically looked at, the main principles of contract or main principles which basically affect and form a relationship between a business organization and consumer. In this case, what we did was we basically looked at studying the contract law, understand what forms a contract, what are the various terms within the contract, implied terms, express terms. We also looked at taking up two examples of the Sale of Goods Act and Sale of Goods and Services Act of 1982. And we looked at in detail with some case examples to understand what are the statutory provisions which have been created, and in the UK Constitution there are some 800, and how they can be applied, to various situations by taking up some cases to show applications and basically examples to show application. We also looked at then buyer and seller remedies, and in this case what we looked at was if you buy goods and services and you're not satisfied with these goods and services, then what are your rights and responsibilities under which you can use some of your buyer and seller remedies to be able to reach a conclusion or solve an issue. In the second learning outcome, we looked at, taking this a bit further, and we basically looked at understanding the different types of credit agreements. Now, we looked at in broad and broadly in general, we looked at the Consumer Trade Act and which of 1974, which basically looks at regulating all the consumer agreements or credit agreements which are formed when you take out a loan or when you're looking at taking out finances or when you take out a mortgage. And we again looked at a lot of case examples through which we understood the types of credit agreements. And in these credit agreements, we looked at, the basic definitions, the key terms and terminology, how you can terminate the agreement, what is, some key terms like cooling off period, early termination. So we looked at various terms involved in relation to, the Consumer Credit Agreement Act and also the types. And then we briefly looked at, the different types of agents which can be formed, by the principal or can be appointed by the principal. What are their roles, roles and responsibilities? And then we also looked at how these agents conduct business on behalf of the principal. Now, in terms of taking this understanding further, we are now looking at covering Learning Outcome 3. And in Learning Outcome 3, we're predominantly looking at studying, competitive law or anti-competitive, law practices. Now, here, this is quite an interesting topic in which we will be looking at, dipping into and refreshing some of the content and our knowledge that we have studied earlier in business environment to understand what is a monopoly, what are the different types, what are the characteristics of monopoly, and then when businesses do trade in the market by offering products and services and get into a monopolistic position, how the law and legislation helps you to, look at, kind of dealing with those issues in terms of understanding, what is a fair price, what is a fair competition, how you can go and complain against, a situation which allows one manufacturer or, producer of goods to become or get into a monopolistic situation. We'll also look at the examples of, when I say examples, we'll also look at some key terms which are involved in understanding, when we say the anti-competitive practice legislation, which is present in the UK and in general broadly within the European Union. The other bits that we will look at in this particular learning outcome would be to understand, some key, organizations which basically look at maintaining fair trade and, obviously work and lobby against, organizations or businesses which work and kind of promote unfair trading or, promote anti-competitive, let's put it this way, business situations in the market or, trading conditions in the market. We will look at understanding the the competitive law, and also some of the key acts which are associated in this particular context. And last but not the least, we will look at understanding when these acts and laws are enacted against an organization, and some of the major bodies which have been created over the years by the government. How did they look at creating a fair playing ground amongst organizations and businesses within the UK and across the EU, and how the legislation affects the trading conditions of these businesses. Now, in certain cases, we will also look at understanding key terms like cartels. We look at some of the key acts which have been introduced over the years, and how these treaties and acts allow seamless trade of seamless working of business trade across EU and UK. So quite an interesting learning outcome in this particular context. And when we look at studying this, what we are looking at understanding is some of the key terms and terminology, and how this can be then applied to from a point of view of a particular business or an organization. So going into some of these slides that I've created, I've got about 22 slides, and the idea would be to try and go through some of them during the course of this discussion, so that you can get some understanding in terms of the key indicative content that we have to cover with regards to this particular learning outcome. So going back again, the learning outcome talks about understanding the legal rules relating to monopolies, mergers, and how anti-competitive practices are monitored, and obviously how they are dealt with within the UK, and in particular in the UK and as a general across the EU. So let's look at starting off with some key terms. When we use the term monopoly, we have seen that over the years, when we use the term monopoly, what it means is that a single supplier in the market, has, more control on the selling of products and services, or a particular commodity in a particular market. So a monopoly, when we say, exists when a specific person or an enterprise is the only supplier of that particular product or service in the market. Now, the verb monopolize refers to the process by which a company gains very competitive advantage against its competitors. That means it is able to gain hold of a dominant position, get into a dominant position wherein it has a significant advantage over its competition in the market. Now, sometimes we do see that there are different types of monopolies which are formed, and when we look at monopolies, they can be formed at various levels. It could be in big businesses, small businesses. It could be across the particular market or a spectrum of market. When I say that, I mean, say it could be in a particular sector like pharmaceuticals, technology sector, financial sector, things like that. Now, monopolies are generally characterized by lack of economic competition. And that basically means to say that there are not many suppliers or not many manufacturers which are providing the same or producing the same type of goods and service which is in demand with the consumers. So in terms of economics, when we look at pure economics, monopoly basically refers to somebody who has this the sole position of being able to sell everything in the market. Now, when we look at the origins of the word, it is best to mention it here. The monopoly as a word comes across from a Greek term called monos, which means alone, and polion, which means to sell. So that means you're the alone seller of the product in the market, and that's why a company is basically then called to have something called a monopoly position. Now, when we look at monopoly, we need to be able to also differentiate a certain key terms and understand certain key terms which come across when we look at the market. Now, when we look at monopoly, it needs to be distinguished from cartel. Now, what is meant by cartel is something that I'm going to discuss in the next subsequent slide. But here, a cartel means a number of providers or manufacturers would work together in order to gain a significant advantage against in a particular market. Not maybe against, but maybe for a particular product or service in the market. Now, this is something which is in sharp contrast to something which is called the model of perfect competition. And where what tends to generally happen is that companies are called price takers, and they do not have any advantage in the market with regards to selling a particular product, but the advantage is really related to something called something around price. Now, there are other various terms which we need to look at just from a point of view of our understanding, which could be things like monopolies, monopsonies, oligopolies, and these are different situations. When we look at studying the economic systems in particular, what we do get to see is that when we study economic systems, we basically come across these terms, and these terms then significantly provide different definitions. So in the case of monopoly, you are basically the only seller or the buyer in the market, and that creates a situation of monopoly. In the case of monopsony, where you have one buyer but many sellers. So in this case, a business which is basically buying and then there are many sellers, there is this particular condition is called monopsony. And a simple example of this would be that sometimes when you look at large retailers like Tesco, Sainsbury's, ASDA, which is a part of Walmart, they basically are able to offer lower prices on certain products and commodities because they are the only buyer in the market, and they are able to grab up all the stock and inventory because of the capacity and the potential to be able to buy all the stock. Now, when we look at duopoly basically means you have two sellers and many buyers. So here, when you look at neither company can behave as if, they have the monopoly, but if they work together, then it becomes a cartel. But in some cases, what they do is they basically look at gobbling up everything in the market from a point of view of buying, say, raw material. Or when we look at situations like, if I give you an example, like Pepsi and Coke, they are in a situation where they are kind of duopoly. So every time when we look at new soft drinks or fizzy drinks coming across in the market, we normally see that the companies are either lapped up by Coke or Pepsi, but they have created a lot of brand extensions over the years, and that is a situation wherein you would probably, it'll be a good example of saying that it's duopoly. Sometimes you also look at a situation wherein there is triopoly. That means three sellers and many buyers. Now, again, in this situation, when you look at a three-company market situation, wherein some of these companies will have sizable control over pricing and production, would basically, give rise to a situation of triopoly. Now, again, these are things that we look at studying in economics, and when we have studied business environment earlier, we have looked at some of these terms, but it's a good way to refresh this areas because when you look at some of these, terms, we also are able to correlate quickly to it in terms of an example. So when we look at a triopoly here, I would look at the gaming market, for example. You have Sony, Nintendo, and Microsoft, which is pretty much they have cornered the entire console of the gaming market. So there are three sellers and obviously many buyers, and these three main sellers then have different varying products, different varying market shares amongst the three products that they are positioning to consumers. So things like Xbox, PS3 or PS4 in this case, and then we look at Nintendo, and that would be an example of triopoly. So when we look at oligopoly, that is the other bit that we look at, and that's the last term. When we look at oligopoly here, what we have is few sellers, normally more than three, but many buyers. So after triopoly, if there are more than three sellers and many buyers, then this basically tends to create a situation wherein the market is showing or is called oligopoly, or showing oligopolistic, characteristic. So here you can look at that, say for example, when we look at say banks, there are many banks in the UK market. When you look at Lloyds, CSB, Halifax, RBS, Barclays, HSBC. So there are many banks, there are more than three, and obviously many buyers or many customers, and that tends to create a situation wherein you have oligopoly. As I mentioned to you earlier, we need to differentiate the term cartel from monopoly, and cartels basically tend to be formed when we see a behavior between competitors, in most cases when they act together to kind of look at cornering the market. So a hardcore cartel in this case would be that you look at price fixing, market sharing, bid rigging, or obviously limiting the supply or production of certain goods and services. Now, when we had the recent financial crisis, you would see that one of the reasons why a lot of these large banks got fined by the Financial Conduct Authority and the various authorities across the globe in the US. When we look at They were fined because they were found to be fixing the interbank lending rate, which is called LIBOR. So London interbanking lending rate, that was basically price fixing. That means the large banks were actually controlling the exchange rate or the trading of currency or certain assets related to financial services, and that basically showed a cartel behavior. And most of these banks were independently fined large amounts of money in millions of pounds and dollars, because these were seen to be practices which were anti-competitive and did not allow free market mechanisms to work. And that is why we look at this as an example of a cartel. Now, there are various characteristics of monopoly, and I think this is something which we can briefly look at in situations to understand why monopolies are formed. So sometimes you see it could be formed because of price maker. That means there is only one company which can decide on the price of goods or products being sold. Single seller, as I mentioned earlier, that means there's only one seller of a product or a service in the market. Sometimes you look at price discrimination. You look at somebody who's able to maximize profits. So when I say an example of Apple here, they would be categorized as something called a profit maximizer. That means they're trying as a company to maximize profits across, and customers are willing to pay, for some of the high-end products that they're introducing, like the iPhone, iPhone XS, the new one that they've recently launched. When you look at some of these companies, they create high barriers to entry. That means they make it difficult for other competitors or companies to enter the market. That also then tends to create something called, monopoly in the market. I've put some additional notes, in the speaker slides for you to be able to grasp and refresh some of these concepts, because what we need to be able to do is understand this particular concept of monopolies and then study it in the context of UK and how the various organizations which have been created by or government bodies which have been created in terms of regulators, which then look at monitoring or kind of look at dealing with the anti-competitive practice legislation in the UK and European market. So let's look at briefly some of these organizations which actually look at breaking monopolies, and obviously look at breaking the cartels so that there is free market trade and free market trade conditions governing any particular market, especially across UK and EU. Now, there is one particular regulatory body which has been created over the years, and this is called we look at some of the bodies, but some of the acts which are related, which have been created as law or statutory law over the years, include the Competitions Act of 1998, which prohibits a number of activities by firms. Now, here what we're looking at is that this particular act actually prohibits the formation and operation of cartels. It prohibits the company to use its dominant position in the market, to gain unfair advantage. It looks at, also working towards ensuring that there is no collusion which happens amongst competitors in order to gain, some fixed price, in order to gain some pricing or some sort of a advantage with regards to selling products and services in the market. Now, some examples that we would say is that when you look at fixing a price, would be an example of something which is being dealt by the anti-competitive practice legislation. When we look at fixing terms for business, agreeing on certain terms, for example, for delivery, for payments, and obviously in some terms, kind of looking at working out some sort of exclusive agreements which allow the companies to split the market in terms of areas of operation, or let's put it this way, types of consumers would also be coined under something called the anti-competitive practices. So some of these terms that we look at have to be understood from a point of view of understanding the Competitive Act of 1998, because this then tends to deal with anti-competitive properties, or practices, not properties, practices in the market. Now, one of the other acts that we need to look at is the Enterprise Act 2002. Now, this act was amended under the Competitions Act, and this was primarily created to strengthen the power of regulators in trying to detect and also to punish the abusive market dominance situation for companies. Now, the main provisions of this act, include the assessment of mergers. So when you look at two large companies merging. This is basically assessed under the Competitions Act and also under the Enterprise Act. Now, if I give you an example of this, the recent takeover by Sky News by Comcast in the US, or when Sky was looking at the original parent company was looking at taking over Sky News or Sky operations in the UK, was being investigated under the Competitions Act is because they want the news to be free and fair, and obviously they didn't want one particular media or regulator to have excessive control on how the news and the news broadcasting is actually controlled or regulated in the UK. So some of these mergers, when large companies merge, are investigated under the Competitions Act and also under the Enterprise Act to ensure that it allows free market rate conditions and it allows competition to flourish, which then provides choices to consumers. Sometimes you look at that, some of these companies do also merge when they look at, same products and services, and they try and merge to gain more market share, a more dominant position against competitors in the market. And that is also, kind of investigated or looked at under the Enterprise Act of 2002. Now, what we also look at is that when we look at this act being reformed, there was something called the Enterprise and Regulatory Reform Act, which was created in 2003. And this act is now under the Competitions and Markets Authority, which is called the CMA. And this authority was launched in April of 2014. And this authority basically looks at the combined current competition and consumer protection function of the Office of Fair Trading and Competitions Commission. So an overarching body which was created, essentially, I would put it this way, which is called the Competitions and Markets Authority, or CMA, and this then oversees the operations, as a key competitions regulator in the UK, and kind of looks at the elements of, the Office of Fair Trading and Competitions Commission. Now, the key role that we see of CMA is basically to look at, combining the two things, which is the Competitions Act of 1998 and the Enterprise Act of 2002, and then look at, obviously preventing the abuse of dominance in the market or the abuse of, market sharing, price fixing in the UK market. Now, the key role of the Competitions and Market Authority, CMA in short, are that they investigate any merger which could restrict competition. They also look at, undertaking market studies and investigation where they may see that the competition would create problems for the consumer. They also look at understanding any breaches of UK and EU law against the anti-competitive agreements which have been established, under the law and legislation. When we look at, specifically this being related to dominant positions for businesses. They also are responsible for bringing across, criminal proceedings against individuals who commit a crime, under the cartel offense or forming of cartels. They also look at enforcing consumer protection legislation to tackle practices and, to also look at dealing with difficult market situations when consumers do not exercise choice or get choice in the market. And then finally, they look at cooperating with, regulators, certain sector regulators, like you have Ofwat, you have Ofgen, you have Ofcon, Ofcon for television and broadcasting, you have Ofwat for water, and you have Ofcom, Con for essentially gas and things like that. So they basically coordinate with sector regulators to ensure that there is, there is enough competition in the market so that consumers are able to get, adequate choices when they look at buying, products and services from some of these authorities. So, I think what I'm going to do is, if I put this role across on this slide, that would be a bit of, that will give you a bit of, clear understanding in terms of what is the role and, function of the CMA. Now, this, the idea of understanding some of these concepts here is to know that when we look at understanding, the legal rules and legislation which are related to monopolies, mergers, and anti-competitive practices in the UK and in general within the EU, we need to clearly understand some of these laws and some of these acts, so that as a business, when you work within a business, and if you are responsible, then you clearly know how the application of these law and legislation can happen in a particular business situation. Now, there are other key bodies which are also present, and they also look at providing services in key areas of UK legislation, and these then are basically looking at I've kind of summarize them under the next few slides. So they provide some sort of a regulatory structure in the UK, and there are some of these bodies which have been created over the years. So there is Department of Business Innovation and Skills. Now this VIS was created in 2009 and then obviously replaced in 2016 with the merger of the Department of Business Enterprise with the regulatory reform in the Department of Innovation, Universities and Skills. So it became a larger department, DIUS, and the main objectives, have been highlighted here. So this looks at, again, the same thing that we talked about under the Enterprise Act and the role of CMA. In general, this is specifically applied when we look at to business innovation and skills. So there's a Secretary of State who drives, and is responsible for this department. And his or her main objectives are they want to look at promoting free trade and fair, trading conditions and, healthy competition in the market. They want to look at increasing productivity and skills within the market, which is to improve job and labor market. They want to look at promoting, obviously science and innovation so that Britain as a market remains competitive and is able to attract the right talent and the companies to come into the UK and invest. And they also look at how to work with various regional bodies to create economic conditions which help in reducing the gap in terms of growth rate across various regions in the UK. So when we talk about regions like, certain regions in the UK, like which are deprived areas or areas wherein there is low economic growth, that is where the Department of Business Innovation and Skills, or DIUS, now comes across and looks at, creating policies and procedures. So it helps those businesses who are looking to invest in the UK to help go into those regions wherein they could go create jobs, stimulate obviously stimulate the economy and create jobs in general to bring across an overall well-being. Now, one of the other bodies that we also want to briefly look at is the Office of Fair Trading. Now, this is an independent body whose main role is to ensure that the markets work effectively. Now, basically, they are going to be looking at any sort of unfair and uncompetitive trading which can be established against the consumer, wherein the consumers do not get choice or do not get fair choice to be able to buy those products and services from the market. So they are basically bodies which are they are semi-government bodies which have been created over the years to try and regulate private entities. And they then look at undertaking, various research and independent studies to ensure that there are fair trading conditions available, and the market is able to then self-regulate and provide competitive prices for consumers to buy these products and services. So the OFC's main objective are also listed here. They try and identify and put the right trading practices in place. I think in the last few months and years, we've looked at that there is a lot of discussion around that some of these companies, which are utility companies, gas and electric companies, are making excessive profits, and that needs to be regulated. So when we look at these companies, different regulatory bodies under the Office of Fair Trading, which is Ofgem, which looks after, which has undertaken a study right now for gas and electric companies to see if they are providing fair prices to consumers. Ofwat, which is generally for water, and then we look at, Ofcom, which looks at the regulatory and TV advertising and broadcasting rights. So they look at these. The Office of Fair Trading basically works with these bodies to be able to look at maintaining free and fair trading practices in the market. Let's put it this way, in the consumer's interest. Now, there's something called the Competitions Commission, and this basically, as I mentioned earlier, looks at, earlier when I mentioned this across, looks at basically the CMA. It is now under the CMA, and it looks at, investigating any mergers, and any deals which are going through the market, which would create unfair trading conditions, or provide non-competitive, prices to the UK consumers. So these bodies, we have to just look at them as of now from a point of view of understanding. We should be aware of them, and what is their main role and function is something that we need to be aware of. Now let's look at some of the other aspects of why we need to look at competition policy, why we need to look at understanding that these restrictive trade practices have to be avoided in order to have fair trading across markets in the UK. Now, I put together a few slides which basically talk about what is competition policy. Now, when you look at businesses in general, they are set up to create profits. They are set up to create or sell products and services. So when you look at businesses in general, they at some stage compete with each other. Now, competition puts businesses under constant pressure because they have to provide obviously the best range of products, but also at the best possible price so that consumers choose them as against their competition in terms of buying those products and services. Now, in a free market, business normally would be seen as competitive because consumers are seen as beneficiaries. That means they're able to produce, manufacture, and sell these products and services, and consumers, when they pay for these services, act as beneficiaries. They get some sort of an advantage or get a fulfillment of purpose when they buy these products and services. Now, sometimes when some companies try to limit competition by getting into the situation of monopoly or duopoly, or when I say triopoly, that is where the competition policy actually kicks in. And that is where the Competitions Commission or the anti-competitive practices, are looked at from a point of view of the CMA, which is the Competitions and Market Authority, and the Competitions Commission. Now, I have put together some slides to give you some more idea in terms of what the CMA and the Competitions Commissions does. So they look at agreements between companies that restrict competition. They look at the abuse of dominant position. Some of these points relate to what we've discussed in monopoly, and they look at obviously mergers happening in the market, like the Sky merger and takeover by Comcast or the American company was looked at in a bit more detail before the merger was allowed to go and happen. You look at some of the big mergers which have happened in the US market, in particular with ATHE, and they're buying out, some of the other big competitors in the market. They were all subject to, the Competitions Commission or a relevant authority in the US before these mergers were allowed to go ahead. Now, there the idea is that they look at primarily these functions so that it allows for free market trading conditions to prevail, which provides choices to consumers. Now, when we look at some of the other things which are related to, looking at how companies are able to get into a dominant position and what is a dominant position. Now, in general, when you look at a company which can restrict competition and get into a position of strength in a particular market, that creates something called a dominant position. Now, when you look at the big four retailers in the UK, when you look at Sainsbury's, Asda, Tesco, and Morrisons, they basically are in a dominant position because between these big four, they control more than 80-85% of the market. But of late, let's put it this way, in the last few years, their dominance has been challenged by the German manufacturers or, bodies like ALDI and Lidl. And when we look at that, what we do get to see is that the government has created, the CMA and the Competitions Commission and the Office of Fair Trading has created, conducive conditions for other retailers to be able to enter into the market. And, then they do not allow some of these big four to get into a dominant position. Now, when you look at that, what we do tend to see the dominant positions act, what do they create? So in certain cases, what happens is if you have a dominant position in terms of a particular product and service in the market, you can charge unreasonably high prices. In some cases, what you could be doing is we get to hear this term that the large four have actually bought into a lot of spaces in the UK, which does not allow smaller retailers to set up their offices or set up their shops, which means that the land, they've kind of got into a strategy of land grabbing. So they've bought out a lot of piece of land wherein there would be some significant developments or creation of, the stores in the future. But what that has done is because of the land grabbing, they've restricted the smaller competitors from entering the market. So this is what the competition commissions, and the CMA look at. And what they try and do is they force them to give off land which they have bought, which then can be sold off to other smaller competitors or companies in the market to kind of come in and set up a business. So when we look at understanding the dominance part of things, when businesses try to achieve that position, that is challenged by the Competitions and Market Authority and the Competitions Commission to ensure that there's a level playing field available across in the market, and consumers get the choice that they get the choice to be able to buy those products and services. Now, the other thing to look at is sometimes we want to understand why the competition policy is important for consumers. Why do you think there is, the CMA and the Competitions Commission needs to create a competition policy which benefits the consumers? So when we look at some of these, basic functions which these two, bodies do, they are making sure that they want to be able to apply those rules to businesses and companies so that they can compete fairly with each other, and this then encourages the, the ability to be able to provide wider choices to consumers, and that helps reduce price and hopefully improve quality. Now, when you have competition in general in the market, what are the benefits you get? You get benefits like low prices because you have a lot of substitutes available, a lot of different types of products available from which you can choose from, and that tends to obviously provide a lower price or a choice for you to be able to buy a lower price product if the quality and the features or benefit that the product provides is the same. Sometimes you will see that the competition is able to also produce goods at a similar price which offers better quality. And this could be when you look at a market like, the baby nappies, for example. This market is, squared between a couple of big brands like Unilever, Procter & Gamble. But because there are only two different brands available, Huggies and nappies, Huggies and Pampers, this is the only choice available to consumers. But between the two products, you get good quality, and sometimes when they compare against each other, they are able to sell against this, each other at more or less very similar prices. But consumers have only two options between Huggies and Pampers. But there are other players which are coming into the market which are able to offer the similar product but at a very significantly lower price. And that is also why competition is better. Sometimes it gives you more choice. It gives you obviously, competition is good because it also leads to innovation. Competition breeds innovation, as we say, and obviously in some cases, when you look at the television market nowadays, what we've seen is that when flat panel televisions were introduced a couple of years back, a decade back, they were quite expensive. But over the years, as a lot of manufacturers have started to produce these, the prices have become very affordable, very cheap. And you could probably look at, a 40-inch television LCD used to cost you about £1,400-1,500 about 3-4 years back, and today that is pricing, is priced at about just about around £200. So what this has opened up is that competition is good in general for consumers because it allows you to get lower prices, better quality, more choice, and obviously in some cases, it leads to innovation. Now, I've got two very interesting videos which basically highlight, how competition, creates choices for consumers. And these two videos you can look at really watching because it explains, why competition is good, how it is monitored, what is the role of, the Competitions Commission and the CMA, and you can relate to this particular situation when you watch these two videos. Now, the other thing which I'm going to briefly go to cover this particular learning outcome would be to look at, we've talked about this particular term of the anti-competitive activity. Now let's understand from a legislation point of view where they are placed both in the EU and in the UK law. So when we look at anti-competitive agreements, they are placed under Chapter 1 and Article 101, which defines a lot of prohibition that these are things which companies or businesses cannot do, and they are then, if they end up doing those, then it is considered as anti-competitive practices. And under this, it could lead to the abuse by, a manufacturer or a particular organization, and that is covered under Chapter 2 or Article 102. So when we look at, these two in particular, what we look at is we need to understand the abuse, and the anti-competitive agreements from a legislation point of view. And just to point that out, what I've done is I've basically mentioned the chapters and the article under which these two particular, laws are covered. So anti-competitive agreements are covered under Chapter 1, in Article 101, and abuse of dominant market position is covered under Chapter 2 under Article 102. Now, the UK government has very clearly said that it will make no fundamental changes in this particular side of law when it leaves the EU. That means after Brexit, we are not looking at making any change, and this side of things would remain pretty much aligned with the EU competition law. Now, the anti-competitive agreements, which are under the Chapter 1, Article 101, both kind of would then be applicable towards EU and companies in the UK, but also having operations in the EU. Now, when we look at this, there are always some exemptions under this, wherein this is not either considered under the anti-competitive agreements or under the abuse of market dominant position. Now, these are classified as something called exemptions under the law. And the exemptions under the law are also clearly defined under Chapter 1, Article 101, and it basically has this particular clause or para which says exemptions. Now here, just a quick example that I would point out and take would be that when you look at some sort of exemption, what do we classify and what do we mean by exemption? Now, an exemption would be that there's an agreement between two pharmaceutical companies which are working to develop a new drug. And this is now being opposed, for example, under the competition law, saying this will give these two companies, say, unfair, advantage with regards to some of the others who do not have access to that drug. Now, when these two companies are working together to be able to reduce or maybe, reduce the time to market or, create that new drug, what this would allow under the exemption would be that this company would be prevented from working independently on that project because they have signed up to do this project together. This would mean that both the companies, when the product is created, would have access to the products and the IP of the product, and that product then would be available to the consumers, and this because it is leading to maybe a faster, maybe the shortening of the life cycle of research will lead to actually faster availability of this drug being made available to consumers. And in such case, the cooperation between the two companies is not seen as restrictive. So this is covered under an exception. Now, this would not be covered, say, for example, they're trying to bring out a cancer research, under cancer research, they're trying to bring out drugs which will be helping to fight or eradicate a certain type of cancer. If two companies are working together in this field to do independent research and their research is leading to, the creation of this drug or leading to reduction in the time to market, then this will not be considered as, let's put it this way, competition or anti-competition. So this will be classified as an exemption. Now, under the abuse of dominant market situation, again, there are some exemptions, and obviously, if there is a breach, what happens and how the law takes its course is defined in the action of consequences of breach. Now, if a company is found to be abusing its dominant market position, then it can face fines up to 10% of their turnover. It could also mean that the court could come in, step in, and provide an injunction. This happened in the case of Apple and Samsung when they fought against each other, for various patents against the Galaxy and the iPhone. And what Apple was able to do is get an injunction in the case of sale of the sale of Galaxy phones within a few markets because they felt that this was a strong infringement into their patents and their technology had been copied. But this was then this led to an out of the court settlement, and the judge actually fining Samsung 580 or I think $680 million in terms of damages to be paid and royalties to be paid to Apple in order to resolve that. So when we look at a company assuming, abusing its market dominant position, what are the consequences of breach are actually covered here. And in some cases, it can lead to fine. It could lead to a court injunction in terms of stopping the sales. It could also mean that under this particular law, the companies could be asked to pay some fines or royalties for the use of patents or infringements which have happened because of that. Now, there are some bodies which are created which allow in the enforcement of this law. And this is basically called the enforcement of competition law. Now, what tends to happen is that there are bodies, obviously, because we are in a bit of a flux leaving the EU, but there are laws which have been created and we comply. The UK side of legislation actually complies with the equivalent side of legislation on the EU side. Now, one of the enforcement of competition law meant was that as long as UK remains a member of the EU, the UK Competitions Authority and courts are empowered to actually apply and enforce this law in entirety under Article 101 and 102. Now, when we say this, what does that basically mean? So when we say this, that UK entities would be able to imply this law in entirety means that under the under the treaty for let's put it this way, under this particular treaty of functioning of the European Union, which is TFEU, which is Treaty of Functioning in the European Union, what this allows the UK courts to be able to do is basically fairly apply the Articles 101 to Articles 106 when they are dealing with anti-competitive legislation and practices of companies which are based in EU but doing their business or obviously selling their products and services in the UK. And this particular legislation then allows the Competitions and Market Authority to act as the principal law enforcement authority in the UK against any of those companies which are having operations in UK and EU. So, for example, OTHM, which is the electricity regulator, when consumers actually buy electricity in the UK, it is being supplied by a lot of different companies which are based outside the UK, but they are regulated under this particular anti-competitions law, and the enforcement can happen through the body created in the UK, which is called OFGEN. And similarly, when we look at other such bodies like Ofwat, Ofcom, and things like that. So the CMA and the regulated authorities, which is the Competitions Commission, have concurrent competitive powers under this law to be able to enforce this law, which is Article 101 and leading up to Article 106, to all companies which are having operations in the EU and and offering services in the UK. And this can lead to any sort of sanctions from looking at fines in terms of their global turnover, looking at obviously injunctions, looking at things like which is to say that the retrospective pay royalties and fines for using the services or infringing patents or say the rights and responsibilities of a particular company, or in some cases if they have created an unfair dominant market position, then some of these companies could be fined for those practices. Now, this basically can also lead to criminal sanctions, and serious breaches then also lead to criminal sanctions where companies or company directors are implicated, and all this falls under the enforcement of something called the competitive law. Now, this is where I would like to stop, and because we've covered a number of things under the Learning Outcome 3 today, and the idea is to understand, the legalities around the basic concepts of monopolies, mergers, and anti-competitive practices in the UK, and how the UK side of law complies with the European side of law, and how, in some cases, the Competitions Commission and the Office of Fair Trading, the Competitions and Market Authority, look at, working and creating rules and regulations which allow businesses and entities to function and work within the market. Now, we've looked at some key terminology, which includes acts. We also looked at some of the main bodies which have been created, and we also looked at some relevant bit of legislation which is required to understand how the enforcement of this law can be done when we do see serious breaches happening or companies getting into a monopolistic situation. Now, this part of the Learning Outcome 3, I've included some speaker notes in certain sections of the slides, because that would be providing the additional reading that you need to do in order for you to be able to understand some of these topics and the law and legislation in place. I've looked at some key references towards the end of the slide, and these websites, if you want to do some additional reading, would be straight away allowing you to read into some of the key concepts which have been covered in today's discussion in Learning Outcome 3. So thanks very much for joining this session today, and I hope you found the information and this discussion useful. Any questions and queries, please feel free to ask via email, and this presentation and some additional handouts will also be available on Moodle shortly, just after this session. The next session and the class that we have, which will look at covering the last learning outcome, for business law, which is looking at dealing with key provisions related to intellectual property rights, is basically slated for delivery on the 21st of October, and that is at 11:30 in the morning. So I hope you can join me then, and we will be looking at doing a discussion on the assignment brief, followed by the discussion on covering the learning outcome 4. Thank you, and take care.